Good evening, friends, and welcome to another edition of Crime Time with DutyRon and Ed Wallace. We are retired New York City police detectives and 9/11 World Trade Center first responders. Hey, if you like all things true crime related from the police detective's perspective, you're in the right spot. Hit that subscribe button, hit that notification bell, so you get all things DutyRon and this guy, forensic guru Ed Wallace, when we go live or upload another video. Tonight, we're going to get into Karen Reed retrial, day 19 and 20. We're only going to do the end of day 19 because last night we went over the recap. Ed's happy anniversary, wedding anniversary was yesterday. He got the day off, but that was a great little premiere that we uploaded last night. A lot of things happening in his trial in those 2 days. I feel like when we miss a day, we have a lot to catch up with. But Ed, a lot of confusion this morning on day 20. Judge Bev came in and called the jurors to interview each of them separately with attorneys present. And I believe that she meant attorneys from both sides, the defense and the prosecution perhaps. But nobody knows because it happened behind closed doors. Everybody had a skedaddle and all the cameras were turned off. Your thoughts, Ed, on day 20, the drama in the morning?
Well, first, I want to give a shout out to everybody. Aloha, ohana. Yes, it was my anniversary yesterday, so thank you for all the well wishers I see in the chat and from yesterday. Yes, so apparently there was a lot of commotion in the courtroom this morning. Something happened that she had to poll each and every juror with 2 questions, apparently. And then, after that delay to the start of the trial, when it came back in later, we'll have reports here. We'll show you in a second. We're not going to give it away what happened, but apparently there seems to be some unhappiness amongst the jurors.
Yeah, there's trouble in paradise, Ed, as they say, right? We had testimony, again, and we're going to cover day 19. Obviously, yesterday and day 20, Dr. Wolf and Christina Hanley were the only 2 experts on the stand for the prosecution. We got cross-examination, very limited, with the brain surgeon, Dr. Wolf, interesting guy from Miami, Florida. And a lot of people in Massachusetts were like, hey, we got some of the best brain surgeons here in Massachusetts. Why did the Commonwealth have to go all the way down to Florida to bring in this guy, Dr. Wolf? I saw that in some of the chats on Twitter and so forth. But we want to say thank you to the moderators, the replay viewers, the super chatters, and all the folks who are positively engaging in all of these live streams. You guys are what makes this a great place, and we give thanks and praise to you. But before we get into it, we want to say congratulations to Melanie Little for hitting that 100,000 subscriber mark. Don't forget, Ed, Melanie started out here with us with 0 subscribers. She started her channel. She was co-hosting with me when you were on the road out of the country. So Melanie, kudos to you. I'm so happy and proud of your success. I knew that she was going to be great and, onward and upward. She's going to hit that 1 million subscriber mark. And she's just going to really do well. And we know that she's covering these trials, from beginning to end, not just this Karen Reed trial, everything that she does. So it's all good. Shout out to Melanie Little and congratulations. All right, let's listen. This is day 20. We're going to go into day 19 because we got to eviscerate Shannon Burgess just a tad bit more because there's just a little bit more that we want to talk live to you about.
Takes the stand, addressing John O'Keefe's head injury.
The only way he could get this kind of an injury was to fall backwards.
Plus, a possible match to plastic debris removed from John O'Keefe's clothing.
The clear plastic from the debris could have originated from the clear plastic from the taillight.
And the courtroom cleared out as the judge takes up an issue. What changed when the jury was allowed back inside? Canton Confidential, the Karen Reed murder trial, starts right now.
It was an unusual start to the day in Dedham. Everyone was asked to leave the courtroom, and then each juror had a private moment with the judge before proceedings could begin. Good evening, everyone. I'm JC Monahan. Glenn is off tonight. Melody Mendez joins us live now outside Norfolk Superior Court with more on that surprise start and then all the testimony that followed. Melody?
Yeah, JC, almost immediately, right off the bat, things were unusual. Judge Cannoni walking into court and immediately saying that an issue, some kind of issue with the jury had been brought to her attention and saying that she needed to meet with each individual juror alone. So she cleared the courtroom. Only Karen Reed, her attorneys, and the prosecution were left in the courtroom and met with the jurors. 90 minutes went by, and when they reconvened, all the jurors were still there, but two of them had switched seats. But Judge Beverly Cannoni did once again address the jury. Here's what she had to say.
I do need to stress for you that it's very, very important that no one discuss this case.
With that, the 20th day of testimony got underway. Prosecution began by calling brain surgeon Dr. Aizik Wolf, who reviewed the ME's report on John O'Keefe and described the laceration to the back of his head.
That's just a classic blunt trauma injury. This is what happens when soft tissue hits a solid ground.
Prosecutors building their case, trying to show that Reed backed her SUV into O'Keefe, sending him falling backwards. Wolf also testified about O'Keefe's raccoon eyes, as he called them, swollen eyelids, and said they could have been the result of impact to the back of his head.
His injuries were very substantial, and it's more probable than not that at some point he quickly became unconscious.
He says O'Keefe would not have died immediately, but says he likely couldn't have gotten up and couldn't have called for help. Under cross-examination, Bob Alessi trying to show the doctor's expertise isn't applicable to this case.
None of your typical days, none of the past typical months have involved forensic pathology, have they? You haven't acted as a forensic pathologist.
I am, if you could have asked that question, very straightforward. I am not a forensic pathologist. I'm a brain surgeon.
Alessi also pointed out the cut above John O'Keefe's eye.
Ecchymosis, raccoon eyes, does not cause a laceration to form on an eyelid, does it?
No.
Trying to show this injury is unrelated to the fall backwards and more consistent with a fight, the defense's version of what happened. Forensic scientist Christina Hanley from the Mass Crime Lab was then back on the stand to continue her testimony, which began Tuesday. Hanley tested pieces of taillight and several pieces of a broken cocktail glass.
It's a physical match.
The defense exacting in on one piece of glass found on the rear bumper of Reed's SUV that did not match the cocktail glass.
Not a single piece of glass on that bumper could be connected to that, correct?
There was no physical match to the glass cup.
The one piece of glass that did match something came from the same source. It was consistent with coming from the same source to the Michael property, correct?
It was consistent.
Reed outside of court on why the defense says that piece of glass is so important.
Nothing on the bumper matched the cup. One piece on the bumper matched a piece found the second week in February by the former trooper Michael Proctor. So he found a piece at 34 Fairview, allegedly, that matched a piece on the glass, on the bumper. Nothing else on the bumper matched the cup.
So on her way out of court, Karen Reed did say that the defense is ready to start presenting their case next week. When she was asked how she feels about that, she said she feels good. She's anxious.
So I want to play that part, Ed. But before I do, I don't want to forget if you had any thoughts about what we just heard right there.
Well, there were several things with the doctor. He talked about gravity and talked about falling and having the head hit a hard ground, but it could be other things. It's not fair just to state that fell and hit the ground. He could have fell and hit something else, or it could be a blunt force instrument, because apparently he just kind of overlooked that there may be a J pattern in the wound. Okay. So we're going to wait for the defense experts. Remember, we're not even into the defense case in chief now. This is all the prosecution's case, and it's looking terrible. So, he's a great at what he does. He's a brain surgeon, but he's not a forensic pathologist, and he's not triple board certified in forensic pathology or in forensic brain examinations. Okay. Yes, he was technically correct about just about all these injuries and the raccooning. I've seen raccooning time and time again, and the brain doesn't cause that, and the breaking of the orbital bones are caused by typically a pressure wave of fluids that are being rushed forward towards the eye sockets after pressure is being applied to the brain, whether it's a bullet impact or creating a pressure wave or blunt force trauma. That said, I think part of his testimony that really helped the defense was like, oh, when I was in Minneapolis, I saw this all the time with drunks who would fall down and hit their heads on the concrete.
Mm-hmm. Yeah.
Okay. So he just gave them, I don't think the prosecution wanted that answer, but he just gave them that answer about, well, John, Officer John O'Keefe was in fact drunk, and could he have fallen down? But here's the interesting thing too, folks. The other day when the defense was getting direct testimony from the Forensic Science 3 Hanley about the trace materials that were recovered from Officer John O'Keefe's shirt, he brought up the Lacard's exchange principle. Okay. Well, guess what? There are many different parts of this case that there is a lack of the Lacard's exchange principle with regards to the prosecution's case, but nothing more bigger than the fact that if they're alleging that Officer John O'Keefe fell back on the frozen ground of the front yard of the Alberts and cracked his head open, he's got no grass, he's got no soil, he's got no contents of soil like little tiny pebbles and other things in his hair or in his wound.
Right.
Okay. How does that happen? And he was found face down per testimony, albeit, it was perjured from Kerry, that they rolled him over. So he was face down. So if he fell back on his head and became incapacitated, as this doctor says, he wouldn't have been able to move, then how'd he roll over?
Right.
Okay. So there's a lot of problems here.
Hey, Ed, friends in the chat that might be just joining us want to know, like, what is some of your experience as it pertains to the medical examiner's office where you could talk about this stuff and have that much knowledge? You did work in the medical examiner's office in the DNA lab, but you did see many autopsies over the time that you were in the crime scene unit and working in a medical examiner's office, correct?
Well, yeah, I had a lot of training in medical legal death investigations while I was in the crime scene unit, and I was trained by many different pathologists, Dr. Dominic DeMeo, Dr. Vincent DeMeo, Dr. Wayne Carver, many of the pathologists that were at the New York City medical examiners at the time that I was there. I would attend their training that they would give us. I was the director of forensic training at the New York City medical examiner's office. But, I had extensive amounts of training in, gunshot wounds, stab wounds, blunt force trauma wounds, time of death issues, rigor mortis, liver mortis, all these different types of training from various pathologists throughout my career as an NYPD crime scene detective and certified senior crime scene analyst. And I continue with the continuing education to this very day. Right. I have to maintain my continuing education to maintain all my certifications.
And the medical examiner, Dr. Scordi Bello, who did the autopsy on police officer John O'Keefe, she started and worked in the New York City medical examiner's office, if my memory serves me correct.
Yeah, right out of college, she did her fellowship.
Right. Yeah. Mm-hmm. So she mentioned that, and I thought that was interesting. Let's take a listen to Karen Reed as she exited court on day 20 today. Let's hear what she had to say. Of course, her attorneys are under a gag order, so they can't really say much, but they are allowing her, which is kind of unorthodox, right? Ed, it's not common practice for criminal defense attorneys to allow their clients to openly speak to the press, to take questions. And she did that today. So interesting. And let's listen to what she has to say. I know this is part of a master game plan for Alan Jackson and the team. They're not just sitting there saying, you do whatever you want. This is all planned, and they have a valid reason for letting her speak to the press. I don't know if it's good, bad, or whatever, but let's take a listen.
The juror?
I cannot.
Jury was? Okay.
No, I cannot.
Wrapping up week 5, how do you feel?
I feel great. I'm anxious. I'm ready to put on our case, which will be more robust than it was last year. So I'm anxious for everyone to learn what we know.
What's the significance of the prosecutor?
More witnesses.
What's the
broader and deeper.
what's the significance of the Proctor piece of glass, do you think?
It matched the glass on the bumper, but the bumper glass didn't match the glass, the cocktail glass, the cup. Nothing on the bumper matched the cup. One piece on the bumper matched a piece found the second week in February by the former trooper Michael Proctor. So he found a piece at 34 Fairview, allegedly, that matched a piece on the glass, on the bumper. Nothing else on the bumper matched the cup. What is the other breaking event of glass? There's multiple sources of glass.
Karen, what were your feelings this morning when there was some kind of issue with the jury? What are the emotions?
We've
like
had
when that
these
happened?
before, so we just wait for the judge to evaluate and let it play out, and it all works out.
She said we've had this before, so maybe she was referring to the previous trial.
Yeah.
She didn't seem too concerned with it, but if you were watching this morning, I watched it on a replay, and Karen Reed kind of motioned towards the jury box where the juries are seated as she spoke into her attorney's ears. That when they came back from sidebar?
Yeah, I saw it.
She was kind of like, and she was kind of, we'll take a look at that, but obviously they know what it is, and she's not going to say. Somebody asked in the chat, could she say disgraced, fired former trooper, Proctor? It would just be for her. It just would be a bad look for her to say that. But she just said former trooper Proctor. She didn't say fired or disgraced. That's for us to say, and that's for anybody who's watching it and giving commentary. She's on trial, so I don't think before the reporters out there, for her to say that would be a good look for her. And listen, there's many people who argue that the jury, this is now going to be 6 days that there's no trial activity. They're off to tomorrow, but Thursday, Friday, Saturday, Sunday, Monday. It'll be almost 6 days that they're off, right, Ed?
Yeah.
It's not a sequestered jury. And are we to believe that they are not going to hear the news from their families or barbecues that they attend over the weekends or functions that I know they're not supposed to, but come on. I mean, there's a chance that they could be out to dinner somewhere or out at a bar or whatever they do on their time off, and this could come up. We hope that they're not listening, but there's many reporters and many people who are talking about this say it's just not realistic to assume that they're all with blinders on. I mean, we would hope so, but I mean, do you think, Ed?
Yeah. I mean, they're not going to admit it.
Yeah.
And if they do, they're going to get bounced off the jury. Okay.
If they say something. If they don't say anything, they're not.
Well, I mean, in the last trial, we lost a juror because apparently they were at an American Legion or something and drinking and talking about the case, and was reported like 4 parties removed to a lieutenant who was involved in the case, and then he spoke up and that person got bounced.
Yeah, let's ask our chat if you feel that the jurors, or some of them, I'm not saying all, but feel that some of these jurors on a 5 or 6 day Memorial Day weekend are going to hear or listen or somehow hear some commentary from some news source or from some podcast or some YouTube channel. Put a 1 in the chat if you think that they will hear something, or that someone potentially could hear something. Put a 2 if you think they're going to be angels and honest and not say, oh, well, I heard this or I did. I mean, it's the buddy system, right? Who's checking on them? Where's the checks and balances here, Ed? Is there a court officer that's following them around? No. So it's the buddy system. We're going on the honor system here.
Brian J., especially with lubricants ingested.
Exactly. Yeah. So Karen Reed also goes on to get asked by the reporters, Ed, out front, what are you going to do on all these days off? And she says, not set my alarm and keep not wear any high heels. Those are the 2 things that she said here. So let's listen in as she starts to walk and talk here.
Glass. There's multiple sources of glass.
What were your feelings this morning when there was some kind of issue with the jury? What are the emotions?
We've had these before, so we just wait for the judge to evaluate and let it play out, and it all works out.
How do you feel about the jury?
I feel good about the jury. I feel good about our selection, and I feel good.
When they asked NJ's last week, you have today, what do you
knowledge? I am gonna have a couple days without an alarm, and without high heels.
Do you know if there's anyone more than just or is he the only one?
I believe that to be the last one. Okay,
So
that is my understanding.
And did your team plan to call Michael Proctor?
TBD.
Still TBD.
Still TBD.
They asked if her team is going to call Trooper disgraced, fired Trooper Michael Proctor, and she said to be determined. They also asked about Brian Albert, I believe, and Higgins as well. So
I'd bring them all in. Bring them in.
She said to be determined. Coexist, and a couple people saying that they better not be listening. And again, look, we're just trying to be real with you guys here. I'm not saying that they are. I'm just saying it's human nature. They're not on a leash. They're not. There's not somebody supervising them all around the clock. Memorial Day weekend, you got barbecues. They're going to kick back and enjoy their family lives. They're going to go out. They're going to, maybe go to other places, and people are going to either be talking about it, or they're going to see it on a TV in a restaurant, or somebody puts a car radio on and you hear it on a podcast or whatever. Who knows? Coexist says, I feel it's absolutely wrong for them to be expected over a 5-day period. For them to be expected over a 5-day holiday weekend to not hear anything about this case. Absolutely ridiculous, not to mention a huge risk for messing up this entire case. Again, we're just giving you the human aspect of this thing. How are we to know if anybody listened, and if they're going to be honest? When Judge Bev says every morning, have you researched anything on this case? Have you, discussed it amongst yourselves? And everybody says no every day, right?
Mm-hmm.
Yeah.
It's a holiday weekend. How are they supposed to have a good time at this weekend, this long weekend the judge gave them, when they know that they can't talk to anybody about the case? They may be at family parties. They may be drinking lubricants and so forth. It's ridiculous to think, and it's not fair. Honestly, it's not fair to them if they're not sequestered. So they're out there. So, you got to watch yourself too as a juror. People may come up to you and test you. Okay. And then go back and report you. So you better be really careful.
Yeah. It's like an IAB integrity test, right?
Mm-hmm.
So let's just scathe. I'm sure everybody has had enough of Shannon Burgess, right? The expert that they brought on, the Commonwealth brought on, that had the BS, the Bachelor of Bullshit. You want to talk just a little bit about, and I'll play the piece after you talk about it.
Okay.
On day 19, he got annihilated again. So Ed, talk about what you were gleaming from day 19.
So this is what I saw. So he obviously got flown in from Texas to testify. And I guess he didn't think he was going to be on the stand for 2 days because he didn't bring enough clothing, because he wore the same suit in back to back. Okay.
Just the tie.
Yeah. And that said, he's not supposed to talk to anybody in between the testimony, because he's still sworn in and technically he's on the stand. So he must have not gotten any sleep last night after what transpired. But he gets back on the stand, and they try to rehabilitate him, and it failed miserably. Okay, there's no rehabilitating that. I'm sorry, just not happening. And then you have recross. So you had your redirect where they try to rehabilitate them. Then you have recross. Now, during the rehabilitation attempt by the prosecutors, they asked him point blank, hey, have you ever told a jury you had this, told a court you had this degree? Okay. And he said no. So basically, he set himself up for perjury. All right, because on recross, unless he brings out the goods, here's the receipts. You were involved in this case in Texas in a federal court, and your curriculum vitae for your expertise was given to that court to represent you as an expert in something he said he doesn't do in this trial, accident reconstruction. Yeah. So that I was really blown away by that, because he says he doesn't do that, but yet that's one of the expertise his company hires him out for. Okay. Then his company, he sends the curriculum vitae to the court per their order, and it's got the degree written in it that he has obtained the degree. Okay. And it's got a year attached to it. All right. And underneath it, it has the associate's degree, and it has a year attached to that. I believe it was 2015 for the associate's degree, or something to that of 2015, 2017, one, in that range. I can't remember off the top of my head. Okay. So then he hits him with that, and he's like, well, who prepared this? He was like, well, either I did or the company. There's no way the company prepared the curriculum vitae. You prepare it, you give it to the company. Okay.
It's up to them to vet it, right?
Right. Well, you would think at that point that there's some kind of HR hire process, and then all of that was already vetted, that, whether or not he had the degree should have been vetted when they hired him. Right. Every job I ever had after I got off the police department, and even when I'm in the police department, I had to, all of that information I gave them about my education, all that stuff was vetted. Okay. It's just mind-boggling. So now, okay, now it's that Scooby-Doo moment, right? Uh-oh, Shaggy. And, okay, what do you do now? Now you just, the prosecutor set you up for that. You said you never did this, and now they have proof that you did it. Okay. And there's, you were working that case. There was, you may have had to have testified in that case. Yeah. And I mean, you're done. You're done. And then he goes over all those certifications and all of those associations that he belongs to. Well, each one of those associations that provides the certification, there's an ethics clause in all of these forensic associations. You violate the ethics clause, you get bounced, you lose your certification. Now, it's going to take some time, but it's going to happen. And just like, is there anybody in this chat that doesn't think he's getting canned? He's getting canned, but not right away. They're going to wait till the trial is over, and then they're going to fire him. Because if they fire him now, okay, his coworker, the vice president of the company, is coming to testify, okay, about the accident reconstruction that he did. And there's no doubt in my mind, folks, that he did not do this on his own. He did not generate that extra work, take that time to do that extra work without first getting pre-approval to do the work. And there's no doubt in my mind that Brennan knew it. Okay. And Brennan is lying to the court. There's no doubt in my mind, because when that next witness from Aperture gets on the stand, who's the vice president, I would ask them, that work that Shannon did he submit the hours that he worked there for you to bill your client for that work? And if so, when did he submit the bill? When did he submit the hours that he worked on it? Because there's testimony now that he called Brennan on the 7th and told him what he had done. And Brennan then tells him to complete the report, not to stop any work, but to complete the report and get it to him, which he does on the 8th.
Yeah.
Okay, so I believe Brennan has some splaining to do to lifeguard Bev.
Big time splaining. Let's listen to a little bit of Shannon get ripped apart here, and we're going to watch him turn 80 shades of red.
Between the time you left the witness stand yesterday until this moment, have you talked to anyone about this case?
No, sir, I have not.
Has a filing ever been made in any court in which your educational background has been
Not that I know of.
represented?
No, not that I'm aware of.
Pardon me?
Not that I'm aware of.
Did I understand that you're based out of the Aperture office in Texas?
Yes, I am.
And are you aware of a case in the United States District Court, Eastern District of Texas, Marshall Division, titled Jeffrey Glover and Teresa Glover versus Graphic Packaging International, LLC? Are you familiar?
Ed, I got a quick question for you. Doesn't the Commonwealth do any background check on the people they call in on a case that they're retrying? Don't they do a little bit of due diligence on the people that they bring in as experts? Wouldn't you think?
They hired the company, and then the company provided these two witnesses, and yeah, you would think that they would have gone over like every case that I've worked on, both in the NYPD and then retired, or any of my contracts with the federal government, any of my private investigation contracts, any work I did privately for defense attorneys and for prosecutors and even judges, I would have to submit my curriculum vitae to them, and they would vet that. And I know they would vet that because I would get notifications of background investigations being done on me because I'm on credit watch lists, right? Okay, or I would get a notification from this organization or that organization telling me that, hey, we just got a call about you, all right? And we to validate your bona fides and so forth. So, that's their due diligence. They're supposed to do that.
So once again, the Commonwealth drops the ball on their expert witness that they're bringing on. This guy's testimony, albeit he probably knows what he's talking about when it comes to the subject matter, is worthless because the jury, how are they going to put in any, how are they going to apply this to this case and say, oh yeah, he's a good, reliable witness? He's not. He's done. He's done. His reliability is shot.
As soon as he heard Alessi mention the case, his blood pressure had to have shot right up.
Yeah, absolutely. Let's listen to this.
Familiar with that case?
Yes, I am.
And is it correct that in that case, well, tell me how you are participating in that case, sir?
So I'm no longer participating in that case. So if I believe correctly, that would have been a accident reconstruction case from, I don't recall, a year or two ago.
And so it was a case that you did participate in, correct?
Yes, I did.
And what was your role in that case?
Sure. So my role in that case was an accident reconstructionist.
But I thought he said he doesn't do that.
Did you provide any testimony, deposition, or otherwise in that case?
No, I did not.
Did you, in that particular case, there were, like all cases, filings made, correct?
I'm sure there were, yes.
With regard to Exhibit EEE, do you recognize the second page, and do you recognize any stamping at the top of each of those pages?
Yes, I do.
And can you describe what that stamping is?
Sure. So that is stamping for a file date of 8/7/2023.
And is that a stamping of a federal court?
That I'm not sure.
If I were to show you a document, might a document refresh your recollection as to whether Exhibit EEE is a filing in a federal court?
Yes.
May I, Your Honor?
Sure.
I am showing you.
Did you show those to Mr. Brennan?
Thank you, Your Honor. I believe I did, but I want to make
And just let me know if we need to move.
We will.
Oh, Ed, look at that.
Can I mark?
Yes.
So as I'm going to pause this for a second. Darkborn, thank you for the 20. He says, you guys are the best. Love the coverage. You all should look at the company's website. This guy's page on their website has been reworked over the past 24, and any mention of his phantom degree has been removed. Remember, it was still there when we looked last?
That was 2 days ago.
Yeah.
Mm-hmm.
So they really cleaned it up. Thank you, Darkborn. We'll take a peek at it before we're done here.
Yep.
Let me just give one first. Sir, I am showing you what has been marked as Exhibit FFF for identification and ask whether or not this document can refresh your recollection as to whether the court filing that you reviewed in Exhibit EEE is indeed a federal court.
Yes, it is.
So that document refreshes your recollection that what has been filed is represented in EEE as a filing in a federal court, correct, sir?
Correct.
Now, what I'd like
The picture that you're referring to is he was at, I believe, the Massachusetts State Bar Association meeting or conference. I saw that picture where they were all sitting down at the table. And then I've seen other pictures of him in Massachusetts giving, I'm not sure exactly what it was because I didn't see him, but he was at the podium giving a speech of some sort.
Can I comment on that last post before this one? The one I put up.
Oh, okay. Go ahead.
You know, I get it. I get it. Humanity, the humanity in us tells us, you know, some people feel, I think this was it. Hold on. Yeah. You felt bad for him. You shouldn't. This man is doing work in a practice, a professional forensic practice. And he is testifying in a case that could remove the defendant's rights
and freedom,
their freedom, and even their life in some cases. Okay. So if you're going to do what he did, I can't justify that. I can't feel sorry for him. He brought this upon himself. I do feel sorry that he was not given good advice growing up, or you know, that he chose the path. You know, he came to a fork in the road and he made the wrong decision. Okay. And that decision had ramifications. Okay. You know, we have to teach our children growing up that for every action, there's a consequence, sometimes good, sometimes bad. You need to think about the consequences before you take the action. Okay. And so that said, also, you know, there's other things about him that were quite disturbing in his testimony. He was asked yes or no questions in cross-examination, and then he injected opinion. Now, I love Alessi. I think he's a genius, but he should have shut that down, and he didn't do it properly. He should have said, I'm not asking for your opinion. I'm asking you for a simple yes or no answer, not your opinion. And not only did he give opinion evidence when not asked, he also gave motive for why other experts did what they did. Okay. And that should have been objected to immediately and struck from the record, and the judge should have stopped it, and she didn't. You can't sit there and tell the jury what you think the motive of another forensic expert is for their report.
Right.
You either agree with their report or you disagree. It's either right in your eyes or it's wrong. You don't say it's wrong and I think he did this for this reason. Okay. That is wrong, and that should have never been allowed. But this lifeguard just let it go, and unfortunately nobody objected to it.
Yeah.
But now you can't put the toothpaste back in the tube after it's out. So the jury's heard that, and but I think it's been offset by his lack of credibility and the fact that he's been shown to have perjured himself.
Yeah. Evie, thank you for your gift and memberships, and also Thunder Horse, thank you for gifting 5 memberships each. Ladies, you are the best. We appreciate you.
Just simply the best.
Draw your attention to the second page of this exhibit. Is that a curriculum vitae of you and a picture of you?
Yes, it is.
And sir, under education,
Objection.
I will.
The objections stayed.
Do you
want to bring it over? We can take
I
it
will,
over.
Your Honor. I will.
Jurors, feel free to stand up and speak.
Get a little closer proximity, bear with me, please. What I would like to do, sir, is to put before you again Exhibit FF for identification and Exhibit EE for identification. And what I would like to do is to ask you some questions, sir, with regard to the process in the case.
Okay.
Are you aware, or do you recall in this litigation that, as typical in litigation, including federal courts, that as part of the litigation process, the parties have to designate their expert witnesses? Are you aware generally of that process?
Generally, yes.
Yes. And have you participated in the documents that need to be prepared for an attorney or a party to prepare documents and submit them to a court to establish the designation of expert witnesses?
No, I have not.
And so you have never participated or never been aware of a process like this?
No, I'm aware of a process, and that process goes through other staff members
Okay, so it goes through other staff members.
at Aperture.
Right. Are you aware that that process is occurring, even though it may be done by other staff at Aperture?
Yes, I am.
And in this instance, you were aware in this litigation that staff at Aperture needed to submit documents in support of an expert witness designation, correct? Even though you may not have done it yourself, you were aware that some person or persons at Aperture were performing that process, correct?
Correct.
And they were performing that process so that you could be designated as an expert witness in that case, correct?
Correct.
And so you were aware of the process, you were aware they had to submit documents that would establish your qualifications as an expert in the case so that you could be designated as an expert witness, correct?
Correct.
And now specifically with regard to Exhibit EEE for identification for these court filings, etc., even though you may not have done it yourself, were you aware that this document, which is EEE, was submitted?
Ed, what do you think of that comment?
I don't think so, Kathy. I respectfully disagree.
Me
Kitty,
too.
rather. Kitty Cat, I respectfully disagree.
Kitty cat. Yeah, that I can't get with that. If I thought that she was and she showed it, then we could say yeah. But it's I know you were just joking.
Submitted as part of the expert designation process we were talking about.
Not this specific document, no.
Were you aware that a CV was needed to be submitted on your behalf as part of the designation process?
Yes.
So you were aware a CV had to be submitted, but you're saying you don't recall this specific one being submitted?
Correct.
Does the timestamp up at the top of each page of Exhibit EEE, including this page that is your CV, match the timestamp, or is it different from the timestamp at the top of Exhibit FFF?
No, that is the same.
So it's exactly the same.
Yes.
And have you been involved in processes in courts where your qualifications, including your CV, have had to be submitted to courts to establish a designation as an expert witness?
Yes.
And can you conclude from these documents, including the timestamps, that the submission that was made to the court to establish your status as an expert witness consisted of Exhibits FFF and EEE?
Gotcha.
I'm going to allow that. Were you aware of that?
Yes.
Your Honor, at this point, I move EEE and FFF into evidence.
See, now by moving it into the evidence, the jury gets to look at it. Okay, it's in now. And you know that any other case that he's ever worked on, if the attorneys involved in those cases are going to be looking at the cases now.
Yeah.
They're going to be reviewing everything now, and you're going to be checking to see if he submitted these false curriculum vitae to bolster his expertise. And there could be a lot of cases that get impacted by this, depending on how many cases he's had while working for Aperture or while working for those insurance companies that he said he worked for.
Do EEE and FFF fairly and accurately represent the submission of documents in support of a designation of expert witness in this case?
Yes, as far as I can tell.
Your Honor, I offer these two into evidence.
I'm going to allow it.
Thank you.
Yes, come on up.
All right.
You have the approach, Your Honor.
Yes.
So this is, yeah. I mean,
He's done. He's done.
the guy's toast, and he sits there and tries to justify it. Okay, enough of day 19. I think we've seen enough of this. Day 20 starts off as we described with Judge Bev calling all the jurors in one by one. We get through that, and then the brain surgeon comes up. Go ahead, Ed.
Actually, before the there was other testimony after him, which were the lab analysts, and then there was the Bodie mitochondrial DNA analyst. I'd just like to talk about that Bodie analyst real quick. He just drove me nuts with his testimony because he would not answer the defense counsel's question of whether or not he could say that that hair was specifically Officer John O'Keefe's hair. He just would, and there would have been nothing wrong with him if he said, I cannot say that it is his hair to the exclusion of his maternal line of family members. I mean, he could have said, no, I can't say that it's his hair to the exclusion of his mother, his brother, his niece, and his nephew. That's all he had to say. I can't say that it's his hair. There's nothing fraudulent about that. It is forensically sound, okay? But he just couldn't bring himself to tell the truth, okay? He had to add, well, you know, his profile, you know, it matches his profile. But that wasn't the question you were asked. See, and I have a problem with a few of the other forensic experts out of the lab who don't listen to the question that they're asked. And instead of giving a yes or no answer, where answering yes or no would not be misleading to the jury. Because I've been on the stand, you know, I've been on the stand quite a lot, 399 times. Okay. Or what was it? Yeah,
399.
399. And when people give me these yes or no answers, yes or no questions, and I realize that if I just answer yes, it would be misleading to the jury. I would turn to the jury and I says, ladies and gentlemen, I can't answer that with a yes or no. It requires further explanation. Otherwise, it would be misleading to you. And so I would throw the ball back into the attorney's court and have the judge make a ruling. And then the judge would typically say, okay, detective, please give your answer. Okay. That's how I would handle that. If it was a simple yes or no question that had no bearing on anything else and then was not misleading, I would just answer yes or no. Like today, we'll get into it a little while later. The lab analyst, the forensic scientist 3, was asked, have you seen this? Do you recognize what's in that photo?
And she could.
And instead of saying yes or no, she said, well, you know, I didn't take this photo and I'm a little hesitant. No, that's just bullshit. She knew what it was because she analyzed it. She may not have taken that photo, but she knew what it was. Stop the bullshit. Listen to the question. Answer the question.
Right.
Honestly. Okay. And, you know, because it makes you look ridiculous to the jury.
100%. And this wouldn't take so long for us to get and to move on to the next witness with that delay tactic and nobody wanting to say, yeah, you know, yes or no, answer the question. You make the defense attorneys, or you make in this case, it's the defense, always having to ask it 100 different times and in 100 different ways. All right. So the Dr. Wolf was, there wasn't really, I mean, yes, he talked about that whole prosecution theory that John O'Keefe fell backwards, and the hit by car theory. He helped them to try to support it. But Ed, you
I have to respectfully disagree with you there. Not once during his testimony did he mention being hit by a car, and he said he fell. His fall was from gravity. All right, falling with gravity. Nothing to suggest that the car hit him. They can intimate that, but his testimony doesn't say a car. They haven't brought out a crash yet.
Right. But he kept going back to that the theory of the prosecution of that John O'Keefe, from the force of hitting being, he didn't say hit by a car, but he said from the force of his fall, and
He said gravity.
Gravity. But the prosecutor kept trying to get him to say what he wanted him to say, and he didn't.
He didn't say it,
which was good.
Mm-hmm.
Do we want to play a little bit of his testimony? Sure. Yeah. So after he goes over his, background and how many surgeries he does a day and how busy he is, he went into it. And let's listen in here.
You moved to Miami Neuroscience Center?
Intracranial pressure increases in the brain.
Have you been part of publications of a number of different books?
Yes.
I won't list parts of all 16 books, but can I point out a few?
Sure.
Were you the author of a book chapter, a characterization?
Basically, the base of your skull is what it encompasses. So the opening at the very bottom is what we call the foramen magnum. That connects your brainstem to your spinal cord. And then as your brainstem goes up, it goes into the different skull areas that, talk about what we call the cerebral cortexes, your occipital lobe, your temporal lobes over here, and then your frontal lobes.
So can you walk us through what happens when someone incurs this type of injury to the back of the head, how it happens, and what are the next steps for a person?
So what happens is, you fall backwards, and the linear acceleration starts to take you back down with gravity. The skull hits the ground. It gets, in layman's terms, smashed a little bit. And then the brain moves forward as a response to that. And it moves forward because you have cerebral spinal fluid and because you have the deceleration, acceleration again. As it does, your skull, if you were to look inside your skull, it's like mini mountains along your temporal bones and your frontal bones. So the brain is being thrust forward at a fairly good speed, and it's getting bruised. You can think of it as if you took a hammer to your thumb. It's really turning black and blue. Those are the contusions. And so the temporal poles and the frontal poles are getting contusions because of that. At the same time, you have a space called the subarachnoid space. And I'm sure they're going to hear about the subarachnoid hemorrhage. And that space is it's very clear, thin membrane that covers all of your brain and all of your spinal cord. And normally, you really don't see it unless you open up the brain and you're operating. But when you either have a traumatic event like this, where little vessels are pulling apart underneath that membrane, or, for example, the classic, when you have an aneurysm burst, the space that the aneurysm bleeds to is the subarachnoid space. The other thing that occurs in trauma like this is you can get a subdural. So the dura is the membrane that covers the whole brain and also right down your spinal canal. And it's a very thin membrane that looks like very thin leather. And in that space between the brain and the dura can be a lot of veins that go towards a central vein called the sagittal sinus. And if those tear, you have a venous hemorrhage from, which is not arterial, so it's not quick, but that can develop into a subdural as well. If you tear a portion of your brain as well, and you get a little arterial bleeds, that could create a much faster subdural hematoma. And so when you look at the pathology, the autopsy of his brain, you're looking at a subarachnoid hemorrhage, you're looking at a subdural hemorrhage, neither one of them which was huge or would have required surgery, as well as the contusions that I described in his frontal poles, in his temporal poles, and then the original bang, which was in the occipital area. These are all findings that you would see on a CT scan and an MRI scan without requiring an autopsy if he had made it to the emergency room.
I want to take a step back at the beginning. You said that this laceration on the back of his head was caused by a fall. Could this be caused by a fall landing on hard ground?
Yes. I mean, like I said, it's a classic blunt trauma laceration.
Do you have an...
And I wanted to ask you too, before you answer that question out, if John O'Keefe, as the prosecution proposes here, that he was hit by a car and went flying 20, 30 some odd feet, and landed on the front lawn of 34 Fairview, wouldn't there be any of the Lacard's exchange principle hair, dirt from the grass? Because don't forget, there wasn't snow. What did the meteorologist say? You would be able to see cat tracks in the snow or cat paws in the
there
snow?
was just enough snow at that point in time when they were alleging the impact to track a cat. Very little.
Would he have dirt? Wouldn't he have hair?
Yes, he would have all of that. He would have all of that. And in addition, he would have broken bones in his arms, broken ribs, not from chest compressions, from CPR. He'd have damage to his neck. He'd have damage to his shoulder, the scapula. There would be all kinds of ligament and cartilage damage. There would be damage to his legs, his hip. There would be so much damage to him from taking the impact of that car and being thrown, as Trooper Paul originally said. It's just, that's why the pathologist says he doesn't have any of the injuries consistent with a motor vehicle accident, and why she could not give a manner of death.
Yeah. Some people in the chat are saying that this guy was a waste of time. He, was irrelevant, yada, 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 so forth and so on.
You know what it tells me? They couldn't get a forensic pathologist to come in and say what they wanted to say.
And they grab a brain.
They grabbed him.
Yeah.
Okay.
Interesting to say the least. It was part of day 20, but moving on, because again, it's Wednesday night. I got work tomorrow. I know you got things to do. I want to try to consolidate this to an hour and 30 minutes. So we're almost at the hour mark. Let's move on to, unless there's questions in the chat. Did you highlight something that
the answer to you, I was asked if we thought that this doctor actually helped the defense. And I do in certain, and more, I think he helped the defense more than he did the prosecution.
Right.
Okay.
And there was very little cross-examination. Alyssa was very respectful with him, and he essentially he asked him a couple of questions, and one of them that stood out too that I thought was interesting is he said, any of your patients, doctor, or any of them dead or alive? Or he said, most of your patients are alive, right? And he said, all of them are.
Mm-hmm.
So just bringing out the fact that, look, you're not examining people's injuries when they're dead. So,
right.
Kind of, I don't know. That was just a little dig there. So let's go on. Alexandria Ocasio-Cortez.
Oh, stop. I can't believe you went there.
Wait a minute. Hold on a second. Yeah. Let me correct myself. Sorry about that. Christina Hanley.
Oh,
did you see the,
I can't believe you did that.
I had to.
No, stop.
Do it. Oh, there she is. So again, we'll listen to a little bit of this, but we're not going to listen to it all. This is the spot where we agreed that we would start. And this is her cross. Everybody's laughing it up in the chat.
For the red plastic, the largest piece measured just for visual purposes, it's roughly like the size of a grain of rice. The rest of the pieces were smaller than that.
Go back.
And who within the lab?
Go back to where?
Just a little bit, because okay. Well, folks, she's about to testify to an ointment tin full of trace transfer evidence that was scraped off the hoodie and the T-shirt of Officer John O'Keefe, and she's going to talk about the sizes. All right. And we're going to show you what it looked like. And I'm telling you, I'm going to tell you what should have happened with the initial analysis by the forensic scientists too, that did the scrapings before the shirt was scrapings. And I'm going to throw the bullshit flag on the field about these pieces. Okay, let's run it.
Clear piece of plastic.
And is that a tin that it's encased in at the time that you receive it?
Yes.
Ms. Gilman, if I could have 9355. And what is this, Ms. Hanley?
So this is a photo of the clear piece of plastic that was within that tin.
Okay. And this was recovered from the shirt, from the hoodie. Go ahead.
Hoodie, yeah, from the hoodie.
Look at the size of that. Okay.
this just a bit.
Now, do you see fibers in here, folks? Do you see foreign fibers and possible hairs in here? Because I sure do.
Yeah.
Right. And I would like to know what kind of testing were done on those things. Could there be dog hair in there? Could there be human hair? Could there be fibers from somebody else's clothing?
Yeah. And
Okay.
This is under the microscope, correct?
No, it's not under the microscope.
So this is just a photograph?
It's just a photograph. You see the letters that are written there? That's not microscopic. Okay. So that's just a close-up of the debris that was the trace transfer evidence that was allegedly found on this hoodie. Now,
poor Dave says no testing whatsoever on any of this.
Well, here's the thing, folks. Here's the thing. First, you're telling me that Proctor and Sergeant Uri collected these commingled shirts from the floor of the emergency room and threw it together in one bag with all of this material on the outer garment, right? On the outer garments, right? And then brought that bag back to the district attorney's office and went into a quote unquote evidence room of some kind, laid out paper on the floor, and then placed these wet items of clothing on the paper for 6 days to dry, and then repackage the clothing at some point in time. We still don't know when that occurred. And then weeks later, deliver this to the laboratory for them to conduct analysis of, and all this stuff stayed on that clothing.
Yeah, that's hogwash.
What happened to the original bags that were from the hospital when it was transported and back to the district attorneys and left out on the floor? They didn't reuse those bags, right? Did they check the bags first to make sure nothing fell off the clothes and into that bag before? Because if the clothing was saturated and wet, as they say it was, then the bag would have been wet and it would have been compromised. So you're not reusing that bag. Did they look in the bag first to see if there's any trace transfer in it and or save that bag and package it up and submit that bag with this the clothing in new packaging? No. Did they package it the way that I taught you all how to package it? No. Okay, because again, it went to the lab, the two shirts commingled together in one bag. Now, when that bag got there, the analyst said she examined the contents of the bag. The analyst said she photographed the front of the shirt. Now, a lot of this you could see with your naked eye, but if she should have photographed it, and if she's seen these hairs and fibers with her naked eye, then she should have put scales down next to it and photographed it.
But she didn't.
We didn't see those photos. Or she should have then done an alternate light source examination on the UV wavelength, and then any foreign hairs and fibers may fluoresce, and then you photograph those areas, long range, medium range, and close-ups with the UV filter, so that you can capture the fluorescence of these hairs and fibers. And then you do a tape lift to collect them, not a tweezer, a tape lift, and collect this stuff. Okay. Also, you should have used infrared photography as well when examining the clothing. So, because you'll get a color contrast, and bits of evidence like this will come out. You can see some of them are quite tiny and may be difficult to see with the naked eye, but that doesn't change the fact that you should have documented all of this instead of hanging the cloth up on a hanger and using a metal spatula and scraping it down onto paper on your desk. How do you know you're not sending this stuff flying everywhere? Okay. A tape lift or the vacuum method would have been the better choice to lift this stuff. And so in here, you see what appears to be tiny broken pieces of plastic, a red plastic and clear plastic that may be associated with the tail light, but and later you're going to get testimony that actually says that. But where's all this documentation? How come the jury hasn't seen all of these documentation of this stuff in place on the article of clothing? It's not as if that can't occur.
Yeah.
I've done it numerous times with photography, and you could take macro photography and get in closer with scales. You could take examination quality photographs. There's so many different ways of documenting all of this.
But Ed, are we surprised that nothing has been done the right way here? And
Yeah,
this
but I would expect more from a certified lab.
She's the lab. She's the third lab number 3, right? She's third grade or whatever, certified third. What's the next step above her?
I think it would be a director.
So she's kind of at the top of the food chain as it pertains to. We heard from testimony that they start out with the state lab scientists 1 and then 2, and now she's 3. You would think that you'd get more out of her, but she was just another.
Well, I mean, this is what she was given. She didn't collect this. The documentation and the collection was the analyst before her, and that person should have done what I just described. Okay. All right. Again, now, does anybody believe that this is just sitting on this cloth? That it survived all this handling?
Yeah. Nobody believes it. Nobody should buy it. And again, we'll go back to Maureen Harnett's testimony from day 15, and we'll see where this came from, and we'll tie it all in. Let's let the rest of this play.
And Ms. Hanley, what are we looking at in this photograph?
I told everybody Ed was pissed off, so you could see it.
This is the photo that I took of the debris that was collected from the clothing items.
Ms. Gilman, if I could have 9366. And again, Ms. Hanley, what are we looking at here?
This is a photo that I took under a microscope of the red plastic pieces that I noted within the debris.
Okay, so this is your micrograph. And that looks about, she said it was, some of the debris, the largest one was like 1/8 of an inch. So that's visible to the naked eye.
Tons of hairs and fibers in here, and wow, it's all intertwined. Here, going through the back, underneath.
And remember, folks, that taillight, none of it is made with glass. There is no glass. It's 100% polycarbonate and plastics. There is no bulbs. They're LEDs. Okay, so there is no glass. Go ahead.
Makeup Mobster is asking, and many others asking the same question. What are we looking at? We're describing it.
You're looking at a micrograph, which is a photograph taken through a microscope of the trace transfer evidence that was scraped off of the hoodie and the T-shirt of John O'Keefe at the laboratory. And you're seeing fibers, you're seeing shards of plastic, red and clear plastic, and all manner of other types of material that has not been identified or classified.
Yeah. And Karen, thank you for your question there, and many others. We don't know if this is dog hair. We don't know what is the contents of any
Are
of
they
this.
fibers from another person's clothing? Could these be fibers potentially that could be matched back to John O'Keefe's fibers of his clothing? Could these be fibers that match back to maybe what Higgins was wearing, or what some of the other people here that the Alberts may have been wearing? We don't know, because apparently not all of it was analyzed.
Yeah. North Carolina Highway Patrol retired. Thank you for being here. We appreciate you. We know you're busy. Thank you for being here in the chat and for watching the live stream. Let's let the rest of this play.
If we could have photograph 9369.
Again, more hair.
Look, this was all from the clothing. How come we don't see this in place on the actual item of clothing?
And Ms. Hanley, what are we looking at here?
This is a picture that I took of the red plastic pieces that I removed from the debris.
Thank you. Ms. Gilman, you can take that down. Now, Ms. Hanley, in reference to your comparative analysis from item 3-1, the taillight housing plastic, to the clear and red plastic pieces of debris from plastic debris from item 7-18.18, the clothing of Mr. O'Keefe, what types of instruments did you utilize in this comparative analysis?
Sure. So after completing my examination, I utilized a comparison microscope as well as a polarized microscope, a FTIR, which is Fourier transform infrared spectrometer, and I also used a microspectrophotometer, also known as a microspec.
And what is a microspec?
So a microspec is an analytical tool that we can use to examine samples that have color. So it provides information on the sample's dyes and pigments.
And how is that utilized in your comparative analysis?
3-cord, the leaf blower was used after John O'Keefe was gone. He was already removed from the scene at that point when Lieutenant Gallagher from the police.
You can't say Lieutenant Gallagher. It's Lieutenant Leaf Blower.
Lieutenant Leaf Blower Gallagher was utilizing the leaf blower after Police Officer John O'Keefe was removed to the hospital.
Slowly I turn.
Now.
So I ran samples from both items that I was comparing, and I compared the data from those two items as a part of my comparative analysis.
I want to fast forward.
Well, get the results though.
Those spectra or graph to determine if they are consistent or not consistent.
I know you spoke a little bit about it in your testimony yesterday, but if you could remind the jury as far as an FTIR, what is that and how is that used in your analysis?
So an FTIR is another analytical tool that we can use. A sample is exposed to infrared light and it reacts in a certain way with that light. And what's produced is a spectrum of peaks and valleys that are representative and unique to your sample. And so that instrument was used to run samples from both items, and then the data was compared from both items.
Now, from your comparison of starting with the clear plastic from the debris from Mr. O'Keefe's clothing, from your comparative analysis of that clear plastic to the clear plastic from item 3-1, the taillight, what did you conclude?
So the clear plastic from the debris was found to be consistent in color and instrumental properties to the clear plastic from the taillight. So accordingly, the clear plastic from the debris could have originated from the clear plastic from the taillight or from another source with the same characteristics.
All right, can we stop it here?
And with reference.
So she can't say she can't say that it's definitively from that taillight plastic. Here's another thing what she says. She says instrumental analysis. Well, what the FTIR does, and what she says, it creates a spectrum. Yes, it does create a spectrum. And it gives you, what it does is it does chemical analysis. So it's giving you the chemical composition of the material. Okay, so it's identifying the various chemicals that are present in that particular piece of plastic, but kind of disingenuous the way she says that. I mean, she should say, based upon the FTIR chemical analysis, it appears to have the same peaks and valleys, the same chemicals in both samples, okay? Suggesting that they're made of the same materials and could have come from the same source. Because this is class characteristic evidence, not individualistic. That's why she can't say that this plastic that's allegedly found in John O'Keefe's hoodie came specifically from that taillight. Okay. So, but again, look how long Proctor had possession of the vehicle, the taillight, and the clothing.
Yeah.
Okay.
Here's her official photograph on the Massachusetts State Police website.
Would you stop? Come on, she doesn't deserve that.
All right.
The lab analyst testifying here is a good person. You don't need to do that.
I wasn't saying that she's not a good person. Both of these people are good people, I guess. All right, here we go, Ed. Do you want to continue with this?
Go.
All right. So I want to hear her on cross, because on cross it gets a little. She's not answering.
From the clear plastic from the taillight, or from another source with the same characteristics.
The comparative analysis you did between item 7-18.18.
Oh yeah,
properties with the red.
A lot of people had questions with this bar graph. Ed, can you explain what?
That's the spectral analysis. Okay, so those little peaks and valleys are the various chemicals that it's identifying in the makeup of the polycarbonate here.
Accordingly, plastic from 7-18.18 could have originated from the clear plastic from item 3-1 or from another source with the same characteristics.
Your Honor, may I publish, and I'm sorry, I forgot.
Is item 7-18.18.
And Ms. Hanley, when you're comparing these two, as far as the data that you receive, what is it specifically that you're looking at in your comparison as far as the data is concerned?
So when I'm comparing the spectra, I'm looking at the peaks in each sample to determine if they are consistent or not consistent.
So, folks,
and if
I teach people how to use FTIR technology, and in fact, Ron came to one of my training courses, and I showed him our portable field FTIR device. It's also a Raman device, Raman spectrometer as well. And so I teach people this. Now, normally, how I've seen these spectrographs produced for court is you have the known source and then you have the suspect source, and they're color coded, and they will overlap them to show you the alignment of the peaks and valleys. That's not that. That's a different technology. That's the microspec analysis, but the other one was FTIR. This is FTIR. I don't particularly care for this mode of comparison. I like the color-coded overlay to show you how all of these peaks and valleys are aligning, and now typically what happens also in the FTIR is we have a library of all the chemicals. And so it tells us what it is. Okay.
Right. So let's get to let's get to Alan Jackson's cross so we could wrap it up and take questions from the audience.
0.8, correct?
It was 7-18.18.
0.18. I left the one out. 7-18.18. We're dealing with a lot of numbers. I'm going to see if we can cut through that here in a second. First of all, you indicated that you were doing a comparative analysis in different, different categorical ways, using microscopy, using the microspec, using the FTIR. I think you also use the FTIR in that as well.
Yes.
And you indicated that your analysis concluded with those pieces could have come from the same source, from the source in 3-1, the taillight. But you're not conclusively saying they did, correct?
It could have come from. They could have a common origin, or it could have come from another source with the same characteristics.
Right. So in other words, another way to say that, Ms. Hanley, is it may have come from the taillight, may not have.
It's a possibility.
Okay. I also want to ask you real quick about the taillight manufacturer. You were shown an exhibit. I think it's exhibit 200, and I think we have that available. With the court's permission, we don't have to cut the lights. I think the lighting is just fine. This is exhibit or a photograph of exhibit 200 that you saw just a second ago. Quick question about that. In your inspection of that taillight, it's true, is it not, that that is manufactured entirely of plastic or plasticine pieces? There is no glass in that taillight, correct?
I have to check my notes. I don't think I noted any glass.
Okay. So in other words, you didn't note any glass inherent in the manufacture of that taillight. It's basically plastic.
Yeah, I think most of the parts were plastic. I'm not 100% sure if the entire thing was plastic. There may have been other material, but portions were plastic.
But you certainly didn't see any glass inherent in the manufacture process.
I'd have to double check my notes, but I don't think I did.
Okay.
All right. Let me just jump in here.
Why don't you?
Go ahead, Ed.
Typically, defense attorneys don't ask a question they don't already know the answer to. Okay. So he knows there's no glass in this taillight per Toyota.
Just wants her to say it, and she doesn't.
Well, she's going to look in her notes, and she's going to come to the conclusion that she has no glass in her notes.
Are your notes in front of you?
Yes.
With the court's permission.
Yes, sure.
Yeah, it's like pulling teeth for sakes alive. Correct. It's with every witness. Every witness.
Now, while she's reading this, I got to tell you, when she was on direct and they kept referring to each of these individual items as 3-2, 3-1, 3-3, 7-12, 7-14. That's not how you do this, folks. You just confuse the jury. Well, yeah, okay, 7-12 is 6 pieces. You should just say it's 6 pieces of glass.
So I did not make any notation that I noted portions that were glass.
Ed, your point is really good. Continue with that.
It confuses the jury when you start doing shit like that. Keep it. The premise you always need to do in courts is keep it simple, stupid. But you don't want to talk down to the jury. You want to educate the jury, but you don't want to insult them. But when the prosecutor is asking questions, well, what the hell is 7? What is 3-2? What is 3-3? And where did it come from? They have no clue, right? They have no clue. But later on cross, you're going to see here, Mr. Jackson puts up this demonstrative display that just nails it.
Right. Yeah, and that's coming quick. Again, if you keep it, like you said, you don't want to put them down or insult them, but if you keep it in layman's terms where everybody can understand it, it comes across so much better because the jury gets to absorb it. You don't lose them because all of this technical talk, they don't know what it is. They don't know. So to keep it as basic as possible is best, but it doesn't always happen.
Great.
So, Mr. Lally.
Final point before we get into the.
Mr. Lally, the point you right here, but that's the point. They want to confuse the jury. Well, that's typically not the prosecutor's job, right? It's usually the defense that wants to confuse the jury, and the prosecutors want to make the points. But it seems like this world is bizarro and upside down and backwards.
Yeah, exactly. Bizarro 101.
The actual analysis on any of the glass. I want to shift gears to just the glass material that you analyzed and that you looked at and you inspected. You saw no blood, no skin, no biological material, no tissue, human tissue or otherwise, on any of those pieces that you inspected, did you?
Upon examination of those items, making observations of those types of material, that's not my area of expertise. I don't think I noted anything that was maybe consistent with that.
All right. So here's a prime example.
You're not in the.
She knows what biological materials look like under the microscope. All right. She's got degrees in forensic science. She knows what this looks like. Right. It's a simple yes or no answer. There's no reason to get into all of this other stuff. Did you see it or didn't you see it? We didn't ask you if it was your area of expertise or whether you conducted the analysis on it. He just asked you, when you were examining these things, did you see it?
Right.
Yes or no? There's no reason for all the rest.
No material expert section of the lab, you certainly would have noted if there was skin or biological material or obvious blood on glass pieces. You're looking at them in many cases, correct?
Yes, I would have made note of observations of anything that I would have noted on the surface.
Great, and you did not, because you didn't see anything. You suggested, right?
I think I just made note. I have to check each item, but I think I did note that there was some dirt debris on some of the items.
But not biological.
I did not note anything that would be maybe consistent with that.
Great, thank you. I want to talk about the comparisons that you did. And you'll forgive me, I'm a visual learner. So I'd like to talk about it in 4 categories.
Okay.
Linear categories. Category 1, item 3-2. Category 2, item 3-3. Category 3, item 7-12. Category 4, item 7-4.
I'm skipping forward, Ed.
3, 2, 3, 3, 7.
Well, he's going to show it now. Yeah, go to the chart.
Here's where he shows it.
Hanley, you see the chalk that's been, or actually what's been marked as Exhibit 205 in evidence on the screen?
Yes.
Is that consistent with what you and I were just talking about at the witness stand?
Yes.
If you'll direct your attention to the screen on the right, just because it's a little easier and I think the laser pointer shows up a little better. You see the 4 categories represented in this exhibit?
Yes.
Okay. So 3-2, I'm going to go over it very quickly one more time, just visually. 3-2 on the left is the cup, correct?
Yes.
3-3 represents the 5 pieces of glass of what we call the bumper glass, A, B, C, D, and E, correct?
Yes.
7-12 is the 9 pieces of glass recovered by Trooper Buchanan at 34 Fairview, correct?
Yes.
And finally, 7-14 is the single piece of glass recovered by Trooper Proctor, correct?
Yes.
Taking these one by one, just so
Hold it right here, Ron.
everybody's seeing.
If this wasn't Bizarro World, this is what the prosecution should have done, okay? But the defense is doing it, right? Because as our to clarify exactly what's being matched to what and what isn't matching anything, and this is such a great cross-examination utilizing this for demonstrative purposes, and the jury's getting 100%.
Right. It's making it clear and concise for the jury.
That's right.
And that's what's important here, and that's what makes it brilliant.
Taking these one by one, looking at starting with the bumper glass, category 2. Piece A did not match the cup, anything in 7-12 or anything in 7-14, correct?
That's correct.
Piece B did not match the cup, did not match anything in 7-12, did not match anything in 7-14, correct?
That's correct.
And
Apparently, they didn't analyze C and D.
Matches in these 9 items, 6 of them, A, B, C, D, F, and K, correct?
Yes.
But what those match, Ms. Hanley, with a cup, nothing on the bumper, correct?
Correct.
And these pieces in 712 were found on the road in front of the Albert's house, not where the cup was, which was on the lawn.
By Buchanan.
Yes, by Sergeant Yuri.
Yeah.
Or E, I, and L. Is that right?
That's correct.
Moving back to category 2, however, there was one thing, item E, that did match something in this series of categories. Isn't that right?
not a physical match, but instrumentally there was consistency.
Chemically.
The only piece of bumper glass, the only piece of bumper glass to match anything else in your analysis, match what? What was consistent with what?
Item 3-3, piece E, was consistent in physical and instrumental properties with the sample that I took from item 7-14.
Which is a single piece of glass on my pocket, correct?
Yes.
But not a single piece of glass, nothing that you analyzed coming from that bumper matched the cup. Did it? Nothing.
Physical match comparison. There was no physical match comparison to the cup.
Now, that was the last piece that was found by the chief of Canton PD, if I'm not mistaken, and that Proctor went out and collected. So, and there's only one piece on the bumper. Now, this defies logic and credulity that hair that was found on the back of the vehicle and those pieces of glass that were found on the bumper, just resting on the bumper, not embedded in it, okay, just rented on a vertical surface, 90-degree surface, resting on top of it, survived being on that bumper and on that vehicle after the prosecution's alleged impact with John O'Keefe in front of the Albert's house, drove back to John O'Keefe's house with that car and in a nor'easter blizzard, right, allegedly, and stayed on that bumper, puts the car in the garage, then backs out of the car, in the morning and hits John O'Keefe's car, and then drives in the snow to McCabe's house, and then drives back to John's house and leaves the car there, and then later on comes back to the car and drives to her house, which is over 30 miles away on the highway, where the car is finally collected by Proctor and Sergeant Urey and put on a flatbed truck and then driven back on the highway, back to the Canton Police Department, then put into the Sallyport garage, and we watch the snow melt from the roof and come down the sides and run over the area where the hair is and run over where the glass was on the bumper. And that glass and that hair managed to survive and stay in place for that entire scenario I just gave you.
Yeah.
Does that sound reasonable to anybody?
Absolutely effing not.
The laws of physics do not apply in Canton.
Here we go. You're talking about the grits. My cousin Vinny. There we go.
Do you like yours al dente?
Emily, thank you for the 5. How many of these jagaloons are still employed? Quite a few of them are still employed. There are, as we know, Lieutenant Leafblower has got a 300 plus 300 and some odd thousand. His final salary, $350 or $300,000. He gets half of that. Thank you, Emily, for the super chat. EKG, thank you for the 2. Why would Brennan take this case? A favor? I don't think a favor. I think that they're just hell-bent on bringing the charges against Karen Reed.
He's being paid big bucks, folks. Your Mass State taxpayer dollars at work there.
Thank you for the $5. Chloe Albert's Revenge. Brennan put the brain surgeon up because it sounds cool, but he works on living tissue. It's different. All he said really was John O'Keefe was killed by death.
I will say this about the brain surgeon, and I was shocked that the defense did not object when he started getting into hypothermia. That is beyond his subject matter expertise. That he was not brought in there for hypothermia. He should not have been allowed to give his opinion about hypothermia or testify to hypothermia.
Right. Yeah. So yeah, I mean, he was brought on by the prosecution, but inevitably helped the defense. Mrez, thank you for the 5. Can we start rating Judge Bev's bitchiness each day of the trial on a scale of 1 to 10? She starts off so nice each morning. Phony baloney. Phony bologna. Love you both. Well, thank you. Emily, thank you for gifting one membership. Helen, thank you for gifting 5. Those memberships really are great. And thank you for gifting them. Dana, thank you for becoming a new member. Evie, the History Chick's mom. Evie323, thank you for the 5 gifted memberships. Charlie, thank you for the $3 super sticker. Much appreciated. Thunderhorse, the cat tracker, thank you for gifting 5 memberships. Darkborn sent in 20. I think I highlighted this one. Love the coverage. You all should take a look at the company website. We're gonna do that. We're gonna do it. And I think I read that one out.
You did.
All About the Shade sends in 10. It's like Brennan told the witness to just answer confidently, no matter how ridiculous. Just like all the I hit him witnesses whose memory got better with time and got shittier once the defense cross-examined them.
Yeah, and the guy could hear through the back of the ambulance doors with the engine running.
Right. That's crazy. LC, thank you for gifting a membership. Appreciate that. Crazy Italian Lady. Oof. Remember for a month? Crazy Italian Lady says he said he had over 700 hours of training certification, which is less than 18 weeks. Talking about Shannon.
Oh, forget about it.
Eesh. Helen Lewis, thank you for the 5 memberships. A lot of memberships gifting tonight. Thank you, everybody. EKG says my cousin lives in the area in his late 20s. He hasn't answered me about meeting up for an upcoming weekend and college visit at his alma mater. Totally unlike him. I'm not pressing it. I don't know who that message was for, but we thank you for the super chat, and I hope you get in contact with your cousin.
Okay.
Ordinary you, thank you for becoming a new member. KW Dread 305, good evening, Mr. Ron and Mr. Ed. Love listening to you guys. I think there should be some new tweaks to the jury protocols with the way social media is and how much access we now have versus this format for jurors. It's inept. Yeah, I agree. I mean, back in the day, juries would be sequestered on really big trials, and that involves bringing them to a hotel, not letting them have access to social media, their phones, the TV.
Or the TV.
It's really it's tough. That's tough for people. Helen, thank you for becoming a new member. Barb RN, thank you for the $4.99 super chat, super sticker. Miss Cosgrove, thank you for becoming a YouTube member. I think I read this one already. Much as she mentioned that he didn't like sidebars. Oh, maybe I didn't. This jury is already frustrated that with how the case is conducted. Judge Lifeguard Bev, we can't call her a judge anymore, alluded to as much when she mentioned they don't like sidebars. Well, I mean, that hasn't been confirmed, but it's got to be frustrating for so many sidebars for these jurors. And she did mention we have to do these sidebars. We know it takes up time and it slows things down, but we're actually ahead. We're ahead. Like, remember that? I think she said it today. Jeff, thank you for being a member for 25 months. Jeff, thanks for the 2. I have to ask how many years, 36 years. He answered that and confused the hell out of everybody because people were like, congratulations, DutyRon, on 36 years of marriage.
Yeah, for some reason, when I post, when we're live, it comes up as Ron, not me.
But I'm 2 years behind him. We're at 34. Ed's at 36.
Rookie.
Yeah, so I'm the rookie. The Fixer send in a $2 super chat, Ed.
All right. Thank you so much.
Wishing all a great, safe Memorial Day weekend. Yeah, Memorial Day is coming up, and it is the kickoff of summer as we know it, right? There's a couple more super chats that came in while I was reading them. Glow, thank you for becoming a new member. Glow T, 5 from Ditto75, who's always here and throwing her pocketbook or purse at us or wallet. I feel bad for John. What he went through that night, these were fellow officers. Terrifying, ultimate betrayal hope and pray he gets justice. And that's what we say every time, right, Ed?
Yeah, they stop being officers when they commit crime.
Yeah, once you cross over onto the other side and walk that on the other side of that line, you are now a criminal. Emily, thank you for gifting a membership and then sending a super chat right up alongside of that. Emily sends in 2 and says, love my cousin Vinny references. We do it all day, every day over here.
Oh, yeah, you blend.
They were actually quoting some of your references in Melanie Little's chat today.
Uh-huh.
So she didn't catch on to him, but people were like, that's Ed Wallace. That's Ed Wallace.
Yeah, it was funny because so one of the people in her chat said, hey, this person that was from the trial testified in the Sack of Suds case. And she goes, oh, she put it up there and she said, oh, I didn't know that. Thanks for the information. And then I wrote back, Sack of Suds was from my cousin Vinny.
Yeah, I don't think she saw it because the chat goes really fast there.
No, she did. She acknowledged it.
Oh, she did. Cool.
Yeah.
So many people were sending her lots of great accolades for that 100,000 subscriber mark. And kudos to her. I can't wait for her to get that plaque and put it on up. And I'm happy that we started with her in her journey. And she said on her chat today, oh, DutyRon showed me everything, about YouTube and how to succeed, how to block the trolls. But you know what? I only told her about, these little tips and tricks and things like that. She ran with it and took it to the next level. So kudos to her. You can't do this without effort. And it's like you get kicked and you get knocked down so many times. And when you get successful and you're doing good, you get haters and people that try to grab you and pull you down. So she's persevered. So kudos to her. And I wish her a lot more success.
You know what Tay says about that?
What?
Hate is gonna hate. So shake it off. Shake it off.
Wow. I don't know, Ed. That's just over the top. Let's get some chatters, some live chatters with questions. Hashtag Ed, hashtag DutyRon. Now's your chance to put, people are laughing, put your questions in the chat maybe that we didn't get to. We just read off all the super chats. Now let's go to the live chatters. Hashtag Ed, hashtag DutyRon. Let's see what you got. What do you guys think so far in the trial? I can't wait till the defense starts bringing on some of their people. It's going to be, but they're saying that the Commonwealth should be done next week. Do you think, Ed?
Well, who's left? They're not bringing in the tow truck operator. I mean, the plow operator. They're not bringing in Higgins. They're not bringing in Albert. They're not bringing in Jen's husband. So it's only the accident reconstruction that I can think of, unless they have some. I mean, we don't have the list. So. Yeah. It's not many people left, so they could wrap up next week, maybe 1 or 2 days with this accident reconstruction, maybe 3, and then it's on to the defense. But I tell you what, the defense has done such a tremendous job. There is so much reasonable doubt here.
Yeah. Ed Taylor Wallace says a lot of reasonable doubt, and we all agree. Aunt BB2 is here in the chat, and I saw her today at Melanie Little. She was very generous with the super chats for Melanie, and Melanie also acknowledged that she was her first channel member. So that was pretty cool. What do you got, Ed? You just
got a question. Our Just Us system is broken. Yes, justice system is broken. Hashtag Ed, have you ever seen someone incapacitated out in the freezing temps for hours without frostbite? No, I can't say that I have. I will tell you this. We had a case in Central Park where a stowaway in a plane fell out of the wheel well after being frozen to death in the wheel well of the plane when he tried to hitch a ride from South America to the United States. And when they opened up the wheels to land as they were flying over, boom, he went and dropped into Central Park, and he was frozen like an icicle.
Gonna hitch a ride, head for the other. Yeah. That must have been an unusual crime scene for you.
Well, we had we had at the New York City Medical Examiner's Office a museum of curious deaths, and we donated it to the Smithsonian at the time before the new lab was built. And then we tried to get it back because we had the space to reopen the museum, but the never did get the artifacts back from the curator at the Smithsonian. But it had all of that stuff in there.
Yeah, here's one from Complicated. Hashtag at DutyRon and at Ed. What happens after this if it's hung?
Well, if it's hung, they're going to, I hope this time they poll the jurors to see if they're hung on all the charges. Remember, there are 3 charges. And if they're not hung on all, then they write down in their document that, acquitted, and hung. Then there's a mistrial, and they'll throw the case out, and then it's up to the prosecutor if they want to take a third bite at the apple on whatever charges are still left.
Second part to that question: if found not guilty, can anyone be charged for anything? Or
well, the investigation is still open. Then, if they find her not guilty, the feds are still watching. All right, and so they could be pull people in to another grand jury in the federal system and start looking at some of the low-hanging fruit in this case and see if they can squeeze somebody to roll.
Schmitty sends in a super chat. How does Lady Gaga like her eggs? Raw, raw.
Raw, raw, raw. Raw, 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 raw.
Oh my. This thing is getting unhinged right now. Hey, but we got almost 6 days. Well, 5 full days of no trial. We're going to be covering some Brian Kohlberger. There's some updates in the Brian Kohlberger case. So there's a lot to talk about. Cindy, what did you have? I'm sorry. What was it?
Right. Take care of Cindy, and then I'll get back to it.
Cindy Ginter sends in 5 and says, maybe Ed and Ron should do a music video. Nice singing. I suck at it. Ed's much better.
Okay, so Electron Ash, 64 megabits, and megabytes, 8 megabytes. That's your our expert Shannon with as they said 1 end, but it's actually 2 ends. But anyhow, he didn't know the difference between these two. Okay, and he was off by 24 hours on his time on some of his documents used in court. So there was no quality assurance, quality control, or any checks whatsoever, no peer review of any of the work that he did. And besides the lying and the academic fraud portions of his testimony there.
Yeah.
So I wouldn't, if they took away the academic stuff in and of itself, based upon this and the times and all the mistakes that were found, I would disregard his testimony if I was on the jury.
Yeah. Crispy Treats being kind said, Ron, you have a voice like an angel. So do you, Ed. All right. So we want to wrap this up, but at the same time, listen, we got a long holiday weekend coming up, Memorial Day here in America. Everyone stay safe out there. If you're going to parties or traveling, it's one of the most heavily traveled weekends of the year. It's right up there in the top 3, I believe. So if you're out on the roadway, be careful. If you're drinking, don't drive like they do in Canton all the time. Not everybody does it, but there's a lot of it going on out there. Be careful on the roads, but at the same time, we're going to miss you guys for 5 days of no Karen Reed. I think it's a good time for everybody to take a break from it and maybe just, go on to looking at maybe some other cases and take a break. It's good for the head to clear yourself of this stuff. And, day in and day out, it does take a toll on you. So it's a good time to take a break and get some mental health in there. What do you think, Ed?
That's right. What is that commercial? The old commercial? You deserve a break today, so get up and get away.
Yeah.
Where were we supposed to go? McDonald's? No, I don't think so.
Somewhere like that.
Okay.
Everybody needs a break, says LC.
That's it.
We also want to remind folks that we do have merch. I'm wearing the Justice Junkie merch, and we have T-shirts, hoodies. This is the Justice Junkie. It says Crime Time with DutyRon and Ed Wallace. Let me go full screen so people can see it, because I don't think a lot of people know about this. But we do have a merch store, and this is the Justice Junkie series. If you are a Justice Junkie, this is the shirt for you. This is a hoodie, but you can get T-shirts. We also have summer like tank tops and stuff for the ladies, pink color in this version. So if you go to our merch store, it's linked down below, and it's always like a little shelf there. You guys can pick up some of our merch. I wear it all the time, and I like to, there's a Justice Junkie water bottle, and there's also stuff like sayings, like Ed sayings and
Edisms.
Edisms are out there. We also have, justice delayed is justice denied, and a whole bunch of things. Stay safe and watch your six. A lot of that stuff is on there. But let's reel it in. A couple more super chats came in, and I want to get to them. We did get to a lot of the questions as well. Larissa Harris sends in 20. Hope all is well with you and your health, DutyRon. Haven't heard you talk about it. I'm trying to keep that off of the public. I'm doing good, but there's like little things that I'm dealing with here and there, but I don't want to sound like a crybaby, and I just want to try to do the best I can to fight this these little things, these curveballs, as we say, that get thrown at us. Somebody made a comment about this. I got this from Timmy Acosta. He's in Italy, by the way. It says, we trust all others, we polygraph. So that's what that says. It's a mouse pad. Pretty cool. I love it. But thank you, Larissa, for inquiring. I really appreciate it. She said, Ed is very helpful with the forensics, investigation, and evidence. Crazy, 35 years after OJ, this is how they investigated.
It wasn't an investigation. They were hoping for a plea.
Right. Thunderhorse says, where did the Oh Hell No shirt go? It's still there. It's there. It's in the merch store. Oh Hell No. That's another one. There's a whole bunch of sayings. Kristen is in charge of that, and she goes crazy with that. So if you want to grab your merch, go and check it out. It's there. We don't try to push that much, but I'm wearing the hoodie, and I figured tonight I should talk about it a little bit. So if you want to be part of the Justice Junkie crew here with Ed and DutyRon on Crime Time with DutyRon and Ed Wallace, go and get it. So there's the merch link. Thank you, ATS. Amber is freaking awesome. She's got a good channel too, a great channel. Go over and watch her stuff. She's covering some of the Karen Reed. So ATS News, go and check her out as well. Joey Brooklyn. A lot of people here have their own channels, and we love to support them. But as you know, we always say this is about Police Officer John O'Keefe, remembering that it is about justice for John O'Keefe. Let's let this play. I always do this at the end.
Braintree native was a Boston police officer who became the legal guardian of his niece and nephew after the children lost both of their parents to illness. You're watching Canton. All the lawyers were a moment to remember. You're watching officer who became the legal guardian of his niece and nephew after the children lost.
I'm not a big fan of them. We do play their stuff, Boston 10, but I love that they do this because I don't see Court TV or any of the other programs like Law and Crime and others that do this. And I think it's really important that we put Police Officer John O'Keefe at the forefront, Ed. That's one of the reasons I keep going back to Boston 10, Can't Confidential, because they do this, and I like that. I know you always have something to tell our audience at the end. I like to give you the final word, Ed.
Hey, folks, thanks for being with us tonight for a little over almost 2 hours? Okay. Yeah, and I know you can get your true crime fix anywhere you like on the internet and YouTube. We appreciate you spending that time with us. I know time is valuable, or as we say, time is money. So thanks for that. Thanks for spreading the word about our DutyRon and I and our show, Crime Time with DutyRon and Ed Wallace. And always, folks, every day I want you to be safe. I want you to be prepared, and I want you to watch your six.
Amen to that, brother. Everyone stay safe. Have a great, fun Memorial Day weekend. We will be live again before Tuesday, I promise. Maybe I'll do something from one of the ponds or one of the nature walks that I do, and we'll talk about different cases. There's a lot of things to talk about. Remember, it's about Police Officer John O'Keefe. May he continue to rest in peace. Good night from Crime Time with DutyRon and Ed Wallace, and we'll see you soon.